It's great to have Marc Elias back on the program. He's a top Democratic election lawyer and actually will be arguing before the Supreme Court on December 9th in defense of federal limits on coordinated spending between parties and candidates. Marc, it's so good to have you on. I want to get into the meat of this case, so maybe we start there. I mean, what is at issue in this particular case?
Yeah, so the campaign finance laws, when they were originally enacted, had both contribution limits, expenditure limits, and reporting requirements. Over time, the Supreme Court has said that limits on independent expenditures are suspect and mostly have fallen. That's what Citizens United was about. But they have upheld coordinated party spending limits. And that's the idea that if you make an expenditure, if you spend money and you're coordinating it with the candidate, then it's just another form of contribution. And so the national parties and the state party committees have had a higher limit than any other spender in American politics that allows them to coordinate some amount of their spending with people running for House, Senate, and president. And Republicans have been trying to strike these limits down for literally decades. I mean, one of the
Yep.
very first briefs I ever filed in the US Supreme Court as a young associate was in a case where they were trying to strike down these limits to allow parties to spend unlimited amounts of money. They lost that case, but they have tried several times to bring another case forward, and that's what this case is about.
Can you talk about well, like there's let's go through this in parts. When we talk about coordination, is there a legal debate as to what counts as coordination? Because I've met, I guess you would call them operatives over my time doing this. And they sort of explain, like, we work with a particular caucus, for example, or something like that. But like, what determines legally if you're coordinating? Is it the nature or type of communications you have, or whether you speak to the candidate versus their staff versus campaign associates? That sort of question, I guess, is there.
Yeah, so this comes up a lot with super PACs. Is what does it mean to coordinate? What does it mean to coordinate a communication? And the rules there can be a little arcane, and there are, as people have pointed out, various ways to circumvent them or to allow more signaling between spender and beneficiary. But
Right.
when we talk about the parties, when we're talking about coordinated, we're talking about fully coordinated. In fact, we're oftentimes just paying about the part. In fact, we're oftentimes just paying about the part. In fact, we're oftentimes just talking about the parties paying bills incurred by the campaign. So when we talk
Hmm.
about party coordinated spending, I want you to think about this, David. You run for House of Representatives and you take a poll, and there is a bill for $10,000 to you from the pollster. You literally just hand it to the National Congressional Campaign Committee and they pay your bill. So when we talk about party coordinated spending, no one is arguing here that it's not really coordinated or that it's, somehow should be on on the bubble. What the Republican Party wants is essentially the Republican Party's funds to be able to use in unlimited amounts to simply pay the bills of their campaigns.
How do you prepare? Do you prepare differently if you're going to be arguing before the Supreme Court than you would in other venues? And how do you prepare?
Yeah, it's a really good question. So I've argued four cases in the U.S. Supreme Court. I've argued hundreds of cases in lower courts, and it is a different preparation, and for two reasons. The first is that when you are making an argument to nine justices, you are trying to get a majority of five or more. Typically when you're arguing before a court of appeals and there are three judges, you're sort of you're aiming your answers at all three judges, right? Like there's not a huge number of cases that split. When they do, it's 2-1, right? It's a relatively small thing. Whereas in the Supreme Court, you have a very wide ideological spectrum of judges, and so you have to be mindful of what each individual justice is, their ideology is, or their jurisprudence is, and kind of how you put together a coalition of five. So that's one thing that's very different. The second is that argument before the Supreme Court has a certain a certain protocol and a certain sort of set of norms and theater around it. And part of that is that justices tend to be very active and ask very, very probing and hard questions. Sometimes they're probing and hard questions, because there are just hard issues. And presumably, if the Supreme Court's taking the case, there are close questions and hard issues. And sometimes it's just justices trying to communicate with each other by raising questions with you. So you have to have a much broader command of the material and related areas of case law that might come up, by from one justice that in a three judge or certainly a one judge, you really wouldn't expect.
Do they basically run on time at the Supreme Court, or is there often like a hurry up and wait type of situation?
So they always start on time. The gavel, the gavel goes down and the justices come out promptly on time. What's different from the last time I argued in the Supreme Court is that different chief justices have run their courts differently.
Hmm.
And John Roberts, when he was chief before COVID, you had a certain amount of time, so you might have 30 minutes to argue. And what that meant is that when the red light went off, okay, which meant you were at 30 minutes, you would finish that sentence and sit down. Like that was it. Like you had 30 minutes. You didn't have 31 minutes or 35 minutes, you had 30 minutes. And in COVID, the justices adopted this new procedure, which they've essentially kept, even though COVID is over, in which you have a certain amount of time. And then the Chief Justice calls on each individual justice to ask any additional questions they have. So these arguments can last quite a long time. It used to be that if there were two arguments scheduled for an hour apiece, you could be sure the first argument would be done on the hour, and the second argument would begin a minute later, and like you'd be done in 2 hours and maybe 2 minutes. The 2 minutes just being the time between the arguments for the lawyers to shuffle places. Now these cases can go on, the arguments set for an hour could go on for 2 hours or 2.5 hours, as we've seen, because of this new procedure.
If we get back to the substance and the kind of heart of this in the broader context of political spending in general, we've had over the last decade or whatever period of time, 15 years, arguments and cases related to individual contributions, super PACs, so-called dark money. Now we're talking about coordinated spending. Do you believe that if there is to be sort of a solution to the status quo of money in politics, that it is going to come piecemeal, incrementally through taking up one piece of it at a time? Or do you believe that there is going to have to be some broader change to the infrastructure around money in politics? And is that even realistic?
Yeah. So look, I think if we're going to have reform around campaign finance, it's going to have to be legislative. I mean, what's happening in the courts, let's just be clear, has been the systematic dismantling of the campaign finance laws and the campaign finance system. As I've been preparing, I've been, going back and obviously looking at past campaign finance cases, which, the good news is I began life as a campaign finance lawyer. I've litigated campaign finance cases actually longer than I've even litigated voting cases. So I'm pretty familiar with them. And, David, to be honest with you, you have to go back quite a bit of time to find the last time that that the Supreme Court has upheld a campaign finance law, and to find an instance in which the Supreme Court has affirmatively restricted money in politics. You have to go back decades upon decades. And so, what we're trying to do in this case, the reason why the Democratic Party, which is who I represent, got involved in this case is because the Department of Justice refused to defend a law that past departments of justice have defended, both under Democrats and Republicans. The Trump administration won't defend this provision of the campaign finance law. So the Democratic Party stepped forward and says, we'll defend it. And I'm arguing to defend it. But if we're going to have meaningful reform, which we obviously need at this point, whether I win this case or don't win this case, we are going to need reform. That's going to have to come through the legislative process.
When it comes to the issue of super PACs, do you believe that the issue of super PACs is directly related to this question of coordinated spending, or should we really be thinking about these as two separate issues?
Well, so here is the danger, David. is, one of the questions I oftentimes get about this case is, well, what's the harm if parties can coordinate unlimited amounts of spending? I mean, after all, aren't they moderating forces in politics? And, isn't that good in an age of super PACs? And, my first answer is, yeah, that's a question for social scientists. I think the data is less clear than people think, but it's certainly not a constitutional provision. The fact is, the founders were quite suspicious of parties, so there is nothing in the Constitution that suggests that's constitutionally protected. So that's kind of a legal answer. But the second thing, David, is that what the Republicans are trying to do here is to say that if you fully coordinate the spending, and under existing law, that was treated as a contribution, right? Because after all, if you're a candidate and I just pay your bills, that's the equivalent of giving you cash.
Yes.
If the Republicans win here, they are essentially going to win one of two ways. Either they're going to say the contribution limits fall, right? Because yes, it's a contribution, but there are no limits on contributions from parties to candidates, and that will be a big deal. Or they will say that there is, in fact, a difference between coordinated spending and a contribution. And that coordinated spending is entitled to more of the protections that we associate with independent spending. Well, that creates the hole for super PAC coordinated spending, for corporate coordinated spending, for all manner of coordinated spending, which is just another way of saying you're undoing the contribution limits, right? Because if anyone can pick up your bill, then and a super PAC can raise unlimited money and pick up a bill from a campaign. Like, what's the point of having a campaign finance system? Which is the reason why I believe this case is so important to the Republicans. It's kind of the next way of trying to weaken a structure that has already been weakened, frankly, by a series of lawsuits brought by Republicans that have gone to the Supreme Court.
Has this been, if we go back to Citizens United or even beforehand, is there any way to see this other than an extraordinary victory for the Republican Party, the way they've been able to weaken a lot of these laws over the last period of time? Like, does the data point to this has been phenomenal for the Republican Party?
Yeah, no, I mean, I think I don't think you could view it any other way. I mean, Buckley v. Valeo, which is the case that decided the original campaign finance laws. This is a case that goes back to the 1970s, kind of put in place a mosaic kind of pieces of how the campaign finance system would hold together. And what we have seen over time is a concerted effort by the Republican Party to pick various tiles out of that mosaic. And starting in the last, I guess it's 20 years, right? Citizens United was 2010, but it was even a little bit before that. The tiles that were being taken out of this mosaic were bigger and bigger pieces. And as I said, you have to go back a while to find an instance in which the Republicans have not won a case that they have brought in the Supreme Court involving campaign finance. So, look, I'm the first one to say that we have had enormous success, and Republicans have not had success in the voting rights arena. But when it comes to the campaign finance litigation, the Supreme Court has adopted a very narrow definition of what can be regulated, and Republicans have systematically narrowed that narrow definition with some effect.
Well, we are going to be watching this extraordinarily closely. Do you get nervous before these? Like, do you use beta blockers, for example?
I don't use beta blockers. I think I must have been too old for beta, to understand that beta blockers would work, because Lord knows I would have probably done it earlier in my career. I get nervous in the preparation. I don't actually get nervous at the court. I don't know what you're like in preparing for your podcast and video videos that you produce, but I get nervous in the production, in the preparation phase. But then once everyone is going,
Yeah.
I'm kind of settled down.
All right. We are going to watch this extraordinarily closely. December 9th, Marc Elias is going to be arguing before the Supreme Court in this critical case. Marc, always great to talk to you. I appreciate your time.
Thanks, and I look forward to maybe coming back after the argument's over and talking more.